And so we're going to go into more specifics of what do you do when you have a problem. And so this is just the big picture. We're going to go into it topic by topic, because whether if it's a water issue, it's going to be held, things are going to be done differently than if it's a road issue or electrical issue. But the general idea is that if you're experiencing a problem with something that is the park's responsibility, and and a phone call to the park owner just didn't do it, there are steps you can take to enforce your right to a safe and healthy place to live. And the main things to remember, and Sandrine touched on this, was you want to document the problem. That is really key. So if you have pictures or receipts, if your toilet backed up and you made your bathroom a mess, take a picture. If you notice raw sewage bubbling up on the lot, take a picture. If there are horrible potholes on your road, take a picture. Documentation is key. Then it's really important. The law really requires that park owners be notified in writing of problems, and that's incredibly important to get further enforcement if needed. So we always encourage people to write to the park owner, and we can help people with that. We have form letters, and you can just proofread or whatever assistance you would like. And then the third step is really connecting with the relevant state department or an relevant expert to kind of verify the problem you're experiencing. So again, that's the broad picture, and we're going to go into it topic by topic, how they kind of look different. So well water. So yeah, it's my understanding that Mountain View does have a well water system, and every community that is, every water system that serves more than 15 people needs to be tested on a regular basis and needs to be, monitored and tested by a trained water systems operator. So this is supposed to be happening in your community. Those water tests are sent to the Water Supply Division, which is a part of the state of Vermont, the government. They review the water quality, and they have testing results available online at times to review. And so if there's an issue that they notice on their end, they take action to make sure water systems are operating safely and legally. But if you're having water problems, and a water problem could be anything from, it could definitely refer to the quality of the water or the quantity of the water. Water pressure is also a critical part of habitability. So, things like sediment or weird smells or weird colors or really low pressure, these are definitely concerns to take note of. And there's a couple options here for how to, so you'd want, you can document it if you keep a water sample and take a picture of the brown water in your cup or what have you. But then there's some options here for enforcement. So town health officers can definitely be called when it comes to water problems. They would, and every town has a town health officer, sometimes more than one. I think I did have, we'll have information about the Heinsberg town health officer in the notes. And they'll be able to identify really obvious problems. If it's a more kind of technical issue, then you could contact the Water Supply Division and ask them kind of for like the history of the testing in your park. Have there been violations? Have there been concerns with the water system? Let them know if you're noticing something strange, and they may require the water operator to change up their testing to check on that. The Department of Health has testing kits that you could do your own water test from your tap. which they do cost money, though we do have a small financial assistance program here at the mobile home program that could help cover the cost of a testing kit if money is a concern for you. And when it comes to water pressure, that's really going to be best to have a plumber come out and verify the pressure and let you know whether that is, within the appropriate range. And really, the water pressure is supposed to be good enough that even at like peak use, everyone is supposed to still have adequate water pressure. That's really how the law defines adequate water pressure. So again, we know hiring a plumber can cost money, but we do have a small financial assistance program to help households, so that paying for an expert is not a barrier to you actually enforcing your rights. So I don't know if we have any questions or further comments on water. Cool.
I do believe that you covered it well.
All right.
One thing that I want to mention is that the town health officer will not test your water.
Right.
It's only the smell and the visual color of the water that they might attest to it and produce a report, but they cannot do testing.
Right. Yeah.
One quick question: does a resident have the right to the report that the town health officer is writing?
Of course, when a report is written by the town health officer, the resident has the right to have a copy, and a copy will be sent to the mobile home park owner as well.
Great. All right, so moving on to septic. So what the law says is that the septic system must not contaminate the drinking water, cause backup into your home, cause wastewater to surface. The way you could tell that wastewater is starting to surface is that there's like wet ground, even on dry days, or a really gross smell on your lawn. That's definitely a concern and something to get checked out. So that's really the standard that the law is using to determine a good septic system.
Please take pictures.
Right. Yeah. Hard to capture the smells, but you can tell us about them on the phone.
Definitely. Come and smell. Yeah.
So if there are septic problems, it's, again, a similar process. You're going to want to document the problem. You're going to want to write to the park owner about it. A town health officer can be helpful, again, if it's a really kind of obvious issue, a smell, really wet ground, backup in your home. Those are sorts of issues town health officers can verify. If the park owner's really not moving, the Department of Environmental Conservation, they monitor and they regulate septic and wastewater, and they have an enforcement process where they can take, people to court or sue, or fine them for not taking care of a septic system. It is important to note this is one of the kind of situations where both homeowners and park owners have a real responsibility to maintain a healthy septic system. Your lease explicitly states, as most leases do, that homeowners will not put anything harmful down the toilet or down the drain. So, things like diapers or, no putting like oil down the drain or feminine hygiene products, things that could clog up the septic. If the park owner is kind of able to prove that you were the cause of the problem, of the backup or the failure, then, they could hold you accountable for the cost of actually repairing the septic system. So it's definitely really important that, you know what to do and what not to do with a septic system so that you are not held responsible for the cost of fixing it should something happen. And it's likely that if a complaint was made, the park owner would certainly be looking into whether, the source of the issue was from your home or another neighbor's home, because those things can definitely cost a good chunk of money to fix. All right. So moving on to electric problems. So, in this one, there's another entity. Electric is a little more complicated because the park owner is responsible for some aspects of it, but also so is the electric company. And then and the homeowners are also responsible. So there's really three parts to this. The electric company is going to be responsible for maintaining the utility poles and the main lines. The park owner is responsible for maintaining the feeder lines that go from the utility pole and connect to your home. And then you are responsible for maintaining your own personal wiring and outlets in your home. So there's a little bit more to this. Some things that might indicate you are having electrical problems: unusually high bills without a noticeable change in usage, getting shocked when you touch your home, that would definitely be the sign of a problem, visibly frayed wires, and meters that can detect stray voltage. So that's something that an electrician would have to do. Depending on the electrical issue, it could be a real fire hazard. If there are visibly frayed wires or you're getting shocked when you touch your home, that is definitely an immediately concerning safety issue. The fire department can be called to weigh in on that. And like everything else, you want to write to the owner, and it'll most likely be very helpful to call an electrician to verify that there's not first a problem with your home itself. Because again, if there's a problem in your home, that will be your responsibility regardless. But if an electrician can come in and verify that there's nothing wrong with your personal wiring or your personal box, then it's likely, that the issue lies with the park owner's part of the electrical system or even the utility. And utilities will generally come out for free to check up on that, is my understanding. And so yeah, definitely look out, keeping track, having a good sense of what your electric bill usually looks like can be really helpful to diagnose an issue with the park's electrical lines. Does that seem clear?
Yes, it does. It does. I mean, it's. I do think that this is something that, especially when it is visible, to know when to call. When it affects your health, it affects your safety. Do not hesitate, because definitely need to feel safe in your own home and on your lot. Yeah.
Definitely. All right, trees.
Yes, trees.
There's definitely a lot of trees at Mountain View. It's a beautiful.
Yes, we noticed.
Though I'm sure that brings its frustrations, because as folks guess, park owners are responsible for tree maintenance. There's the habitable lot and park rule. But really they're only responsible for removing hazardous trees. So, you can, if you have a concern about a tree, this is one in particular where it's going to be really critical to get an expert opinion. I've just noticed over the years, park owners are very sort of hesitant to act on a tree complaint unless there is real proof that there is a hazard. And there's a couple different options for, you know, I recently learned that there are tree wardens in every town. That's a volunteer role that towns have. And it seems like at least some of them are willing to come out and actually inspect trees and provide their input and write up a little note about their observations, which could be used as sort of that expert opinion. The Division of Forests may also be a good place to go. We'll keep you updated on that. And so, yeah, so this is one where it's going to be really important to get an expert opinion. It can also be, you know, if you have homeowners insurance, it's a really good idea to make sure you let your insurance company know that there is a hazardous tree on your lot, and that, you know, if something were to happen, that it is the park owner's responsibility, so that your insurance company can go after the park owner should something happen. So yeah, so if if you don't have insurance, you know, the park owner is still responsible for the trees. And then it's just more like you'd be working with us at the mobile home program and you know, other folks to get that taken care of.
Yeah, one thing that I can mention is that especially for the trees that are at the border of the park, near a city road or interstate road, you'd have your park owner say, "Oh, that's not my responsibility. This is a city or the town responsibility." Make sure that it is true, and you can do that by calling actually your town office and ask them about the trees that actually is the responsibility of the town or the city, because indeed if they are, then the park owner is not responsible. But sometimes we have heard a lot about, you know, the excuses, oh yes, near to the road, so it's not our responsibility at all, when it's actually not the case, because it's definitely right at the border between where the park owner property starts and the city then ends. So I make sure to double check on that.
Definitely. Always good to double check anything the park owner says for your own protection. All right, roads. I think of all the habitability issues, we probably hear most about trees and roads. So what the rules say about roads is that you need to have a safe and reliable entry and exit. There needs to be adequate and timely removal of snow. There needs to be efforts made to mitigate icy conditions all winter long and spring, all spring long too. And the roads should be reasonably free of hazardous potholes and depressions in which surface water can accumulate. So,
this is a great picture there.
Yeah, I'm sure we've all seen a road in Vermont, whether it's a dirt road or a paved road, they're out there. And so really, you know, what the way that the Department of Housing and Community Development has interpreted these laws around roads is that roads need to be passable by emergency vehicles at all times. So that would be your ambulance, your police car, your fire truck, things like that. That's kind of the standard that they're basing their enforcement on. And I should have mentioned that, you know, for trees and roads in particular, it's the Department of Housing and Community Development that really has enforcement power versus, you know, for water, for example, or for septic, we talked about the Department of Environmental Conservation. So there is different agencies depending on the problem. But for this one, it's definitely Department of Housing, Community Development. And again, super important to write to the owner, super important to take pictures. You'd be surprised. Sometimes a picture alone is enough to get the Department of Housing involved. If it's really obvious, if your road looks like this one in this slide, take a picture and work with us, and you know, Department of Housing will definitely, you know, take note of a road that looks like this. But some ideas for kind of where to go for an expert opinion on your road. Sometimes local fire departments are willing to come out and just give a look over, or maybe if you have a volunteer firefighter in your community, I think there is one actually at Mountain View. You know, they might have an opinion. If people have home health aides or regularly need to access emergency health care, they may have a good relationship with an ambulance driver or some other emergency personnel who could attest to the conditions of the roads. I think also some towns do have a highway division, and which maintains, you know, the town's roads, but it could always be worth giving a call to them to see if they'd be willing to come and see whether the roads fit their standards that they hold for the town. So there's a lot of different kind of options for this one. But again, if your road really looks like the one in the picture, like there's not much expert opinion required for that one to get the Department of Housing interested. And I think the thing that can be kind of more tricky is in the winter time, talking about adequate and timely removal of snow and keeping ice off the roads. That can be a little trickier to kind of get proof of, but that's where taking pictures is really key, because one day it might be really snowy and you couldn't drive, and the next day it could melt. So if you see a problem on your road, take a picture of it. It'll be really important. All right. Okay. Drainage. Another thing of the law, mobile home park owners supposed to provide adequate drainage to prevent standing pools of water, erosion, or sinkholes. Really, this becomes a real issue if you have a lot of water flowing under your home or under an addition on your home that can really cause damage to your home. Document it. Get pictures. If you have if you know a local mobile home repair guy or dealer, they might be able to come out and inspect and give you an idea of what the problem is as your expert opinion. But yeah, this is a serious issue that can really impact the integrity of your home. And really, again, this would be a Department of Housing and Community Development topic. Common areas. So if you have any common areas in your community, they need to be maintained by the park owner, but also there is a responsibility for residents to use them appropriately and use them in a manner that, you know, doesn't damage it or prevents other residents from using it. And that extends to your guests. All your lease terms actually do extend to your guests. That's clearly stated in your lease, that, you know, you're expected to hold everyone in your household and people who visit you to those standards for the benefit of the community.
Yeah, and that simply means that anything that your guests are doing that are not within the lease terms is your responsibility, even though they are their own people, but they are actually present in the park because you invited them, or because they are actually there with your permission. So you are responsible for their behavior, you are responsible for the actions, and that's definitely something that you have to take into consideration.
Yeah, and so, and this touches on it, peaceful enjoyment. You know, everyone wants to live peacefully and have a little peace and quiet. Mountain View definitely can be a very peaceful seeming place. But yeah, it's, you know, that this is a right under the law of peaceful enjoyment, and again extends to guests as well. All right, so so this is kind of another thing of like, what do you do when the park owner is not taking care of something? We talked about some of the bigger issues, you know, the really major infrastructure problems. You need enforcement, you need to document. But for more minor issues, like say there's a fence, you know, say that your home is on the edge of the park and there's a fence that marks the line of the community and it's broken and it's annoying and it's ugly and you've complained to the park owner and they haven't done anything about it. Well, you have the right actually to give 30 days notice to the park owner saying, if you don't fix this, I will, and I'm going to deduct it from my rent next month. The main key though for this is that you can only deduct up to 1/2 of 1 month's rent. So if it costs more than 1/2 of your rent, we would probably recommend you not move ahead with that repair, because you will not have the right to deduct the whole thing. So this is again for very minor things that are of pretty low cost. And notice is required to the park owner before you do this. Written notice must be given to the park owner before you decide to repair something yourself and deduct it from the rent. And yeah.
Yeah. One thing that I would say about this is that this is not something that we actually advise. This is a last resort, because this flipped the responsibility from the homeowner, from the mobile home park owner to yourself.
Mm-hmm.
By withholding the rent, you take something that is that you have actually contracted that you will do every month. And now it is your responsibility to show the reason why you do so. And that's the reason why usually we do not recommend that. We do recommend mediation, make sure that there is a conversation going to show exactly why it is imperative for that repair to be done in a timely manner. But the other thing that I would say about that, deducting money from the rent is that if the landlord decide that it's not something that he will accept, at the end of any contract, you can say, no, you owe me rent. You owe me half of that month's rent. Nobody told you to go and fix anything. I was about to do it the next day.
Right.
So be very careful when, if you do, because if it, and hopefully it never happens, but usually it's what happens, right? You are required to pay that half month. You need to have it right away. And putting that amount into escrow or into a block account or something to make sure that you have it on hand is definitely a best way to do it, and not spend it, because you never know what the legal course will bring as outcome. So that's why we do not advise that, but it's a course, of course, it is within your right to do so.
So, and just for clarification, when you are going in a situation of repair and deduct, should you really then get the owner or the landlord's, consent that you can go ahead and fix it or get it fixed before you take that step?
I think the main thing that seems, I mean, if you do, cool. I mean, that would probably be the most watertight way to do it. I think the point of this law, though, is if the park owner is not being very communicative, this is an avenue for homeowners to pursue. But like Sandrine said, it is a risky one. And so that's why following the process is incredibly important. You need proof that you sent that letter to the park owner and gave them 30 days to fix it. You need proof that you had tried to communicate before that as well, and you want proof of the cost of the repair and why it was needed. So it's just, you'd want to be really on top of your game, documenting why this was needed. Yeah.